in the form of a representative office. In Malaysia, a foreign law firm can practice in the country by forming a joint venture, a joint law venture as they call it. Similarly, in Singapore, a foreign law firm can practice in Singapore by having a joint law venture or a formal law alliance. In US, you need to give a bar exam. Similarly, in Russia, similarly in Brazil, you have to give a bar exam, and in South Africa. In Russia, there is a special Russian register maintained by the Ministry of Justice, where a foreign advocate has to get enrolled. So each of the jurisdictions have evolved their policy depending on how the local circumstances are, and possibly we will also find the right fit for ourselves as we go forward. Now, a few issues on how it impacts the legal system, how the liberalization will impact the legal system in the Indian environment. On the individual practicing lawyers, essentially there is no impact till we reach the phase when they are allowed to do litigation court practice work. Rather, during the phase 1 and phase 2 that we were discussing about a little while ago, there could be far better training opportunities, and depending on opportunities by foreign law firms to recruit Indian lawyers to be a part of their team, a better earning opportunity as well. For law firms of various sizes, the issues range quite a bit. Competition will definitely be at the doorstep in terms of practice area and pricing. Firms will have to thrive to perform better, to sustain the positions and the landscape the way it stands today. Talent is something that will be really high value issue to chase, because with the foreign law firms coming in, talent could be in very high demand. Talent and client retention is something that law firms would be most impacted with. How and in what manner and what size of law firms it impacts is something that is yet to be seen. Law universities and academicians and students, as I mentioned a little while ago, better learning and earning opportunities both. General counsels, foreign lawyers will add to a wider expertise in terms of offering to the GCs on issues of foreign law, arbitration, essentially the permitted areas of practice that we're talking about. BCI draft rules already Dr. Bhasin spoke quite a bit about, so I don't want to repeat much because it's essentially a factual issue, and it does, I'm completely in agreement with him that it's a document which requires a huge amount of working and change and improvement. How that could evolve, we will obviously see based on the inputs the government gets from the stakeholders concerned. Essentially, it permits registration of foreign lawyers who meet the eligibility criteria. Law practiced by foreign lawyers, the nature and extent is provided, essentially in the permitted areas of transactional practice, international law and arbitration. There is a process for a fee, 25,000 for individuals, 50,000 for partnership firms, and also a process for deposit. The registration is for a certain fixed time. I don't want to get into nitty-gritties. There's a process for renewal. There's a process for cancellation in case of non-compliance of the terms set out in the BCI rules and the registration as and when it is granted. A quick look at the roadmap, possibly, a possible roadmap, because so far the kind of time it has taken, over 2 decades, this roadmap could be completely off the mark. But coming from the present circumstances, the kind of push the government is giving, I've still tried to put some kind of a roadmap on this. The process starts with the stakeholders consultation, which has commenced with the BCI giving the first draft of the rules and the law secretary calling the stakeholders as available in the process already carried out in the past. And mind you, the government is also learning on this. The government is also evolving itself. So the IMG and the earlier processes have thrown up stakeholders which are already part of the processes. And as we go along, more and more stakeholders would get added to this list as an organized input to the government in formulating the policy. So the stakeholders consultation is where we stand today, and it's likely to take a few more months, if I can say, not weeks. Thereafter, we need to review the Bar Council rules and get a handle on what exactly the language of the Bar Council rule should be. So the study of the different models in different countries and what changes the Bar Council rules requires is underway at the moment, and stakeholders would be giving their inputs. SILF is already working on a team. We are working with another bar association, International Bar Association, to give our inputs as well. And I'm sure there are quite a few other stakeholders who are also giving their inputs in the process, so that as and when the Bar Council rules are shaping up, all stakeholder views are taken in. OP Jindal is already doing, just to name a few, OP Jindal is already doing a discussion to throw up ideas not very long away from now. ICA, another body of corporate councils, is also similarly. So all the stakeholders, BTICA is leading the pack with the first discussion on because I mean you have to put the stakeholders, so leading the pack in that sense, I would say, as a thought leadership. She has been able to put together the stakeholders in the first discussion on the issue here. Assuming that the Bar Council rules take shape and the policy on this does take shape, we would have the opening up in 3 phases or 4 phases, as Dr. Bhasin was also mentioning. The understanding from the present circumstances appears to be that the first phase could be around by the end of Q4. We are in Q3 at the moment, and followed by phase 3, up to phase 3 in the next 3 years. Let's see how things emerge from here, because it all depends on a lot of will and directional push by the government, who is the largest stakeholder in this, from the larger perspective of the transformation of India into what we intend to be a $5 trillion economy in about 6 years. So with that kind of a push and horizon, I think the largest stakeholder is the government of India and every other stakeholder along the way. With this, the implementation would commence, and all the challenges that are thrown up along the way will have to be, the whole effort will have to be a curative effort as we go along, because as I said, the stakeholders have varied, and as the process moves on, there could be more and more stakeholders standing up and saying, okay, I'm also impacted in this manner, or this is right, this is wrong. Some of them going to the courts, where it could be tested on issues of violation of fundamental rights, and the courts giving their own views. So as we go along, the curative efforts will also be involved. And then hopefully someday, not very long from now, we would possibly see the legal market completely opened up. Some of the quick issues and challenges, a lot of them have already been touched upon by Dr. Bhasin. Yeah. So I'll just expedite it. Yeah. So some of the issues and challenges, of course, the LLP, while the foreign law firms are structured as body corporates, we are not allowed to practice as body corporates. So that's one major challenge where the Bar Council of India needs to fix. Similarly, on reciprocity, which is just now we can practice based on reciprocity, how it emerges when the foreign law firms are allowed, that issue will have to be fixed. Multidisciplinary practice is again something which is a wish list of the corporates, whether law firms in India will be permitted to provide multidisciplinary services, and issues of advertisement. Some of the future trends, I'll not read out, possibly the PPT can be circulated. Some of the future trends that we can look for from now is better ownership structures, better fee structures, better ethical environment, moving on, better quality of training, and everything that goes with an open market and a market where every law firm or every stakeholder has to compete with the best. I think all that is likely to come in, but at what stage, in what manner, is something that we'll have to wait and see how the whole process moves forward. So this was the overview. We'll now move on with the discussion with the panel. Thank you so much. May I request? I request Amar to.
You can try this one. It's okay. I'll just.
Okay. So Dr. Bhasin, Bitika, Manoj, Ramesh, Tushar, and the members of the legal fraternity. Dr. Bhasin started the session with a beautiful narration of where we are, the way forward, the road ahead, and how we should achieve the end objective. And Manoj rightly gave a overall bird's view of what it is. I just have a data with me. This is a World Bank data, and it has categorized 189 countries, and this is June 2015 data. And it has categorized 189 countries and ranked them on the parameter of ease of doing business. India is 130 in terms of ease of doing business. And when they talk about ease of doing business, they take certain parameters, which are regulatory convenience, regulatory constraints, and India falls at 130. One important category under this ease of doing business is enforcing contracts. So how easy it is to enforce contracts. And out of 189 countries, India is 178. I'm not saying, World Bank is saying. Now, definitely there is a need to do something. And if you see last 1 year, what has happened in the legal arena. Few days back, I was talking on the recent amendments on the Arbitration Act. Now, it's a great change in the Arbitration Act. Three things, I mean, when I talk and I see the amendments, three things have been done. The time period for the arbitration to pass an award has been fixed. The fee for the arbitrator, the model fee structure is already there in the new Amendments Act. And the third is the interference by the court has reduced drastically. So even under Section 34, earlier you just filed Section 34 and the award is stayed, it is no more a case. So these three major worries which any litigant, any contracting party used to have, has been taken care of. Commercial Court Act, and yesterday I read that the judges for the commercial division in Delhi, the judges for the commercial appellate division, they are all have been appointed. NCLT, NCAALT, the judges have been appointed today. Insolvency Court Bill. So if you see last 1 year, there is a tremendous progress on the legislative side to improve the overall scenario in India. Now with this background, if you see today the whole discussion and talk about the entry of foreign law firms and the thrust of the government to increase the FDI in India, I mean, how will it all happen unless we support them with an appropriate legal structure? And one of the ways definitely is to allow the entry of the foreign lawyers in India. Now, nobody is opposed to that foreign lawyers must come to India. The form and the manner is something which we are discussing. And I had a chance to go through each and every provision of the draft rules. And I totally agree with Dr. Bhasin that they have just killed phase 1. And one immediate example is, if you see the definition of advocate under the Advocates Act, it refers to a natural person. and just see the definition of foreign lawyer under the draft rules. It includes the artificial juristic corporate entities. How can you do it unless you amend the Advocates Act? You are bringing the foreign lawyers within the purview of the Advocates Act and BCI rules as far as the disciplinary proceedings are concerned. How can you do it unless you amend the Advocates Act? These foreign lawyers are so adept, so used to solicitation, advertisement. Whether they will survive in India without advertising themselves? Should we allow them to advertise? And if we do so, why shouldn't we allow our own legal fraternity to advertise? What is wrong in that? The fee sharing component. If you see the present act, they can't share their remuneration or a fee with a non-legal lawyer. While the draft rule does talk about an undertaking under which the foreign lawyer will not be allowed to practice Indian law. But at the same time, if you see, they're allowed to hire Indian lawyers.